5 seconds to go. Start. A careful reading of the second order of this court, dated 4th June 2024, would show that this court recorded that they did not propose to go into the arguments or dwell upon it in view of the liberty granted in the first order of this court. Thereafter, this court noticed the assurance of the learned Solicitor General that the investigation would be concluded and final complaint charge sheet would be filed at any rate on or before 3rd July 2024. This court further observed in its second order that since the period of 6 to 8 months fixed by it in its first order had not come to an end, it was inclined to dispose of this petition with liberty to the appellant to revive his prayer. It will be a travesty of justice to construe that the carefully couched order preserving the right of the appellant to revive his prayer for grant of special leave against the High Court order to mean that he should be relegated all the way down to the trial court. The memorable adage that procedure is a handmaiden and not a mistress of justice rings loudly in our ears. In this respect, we may also gainfully refer to one of the recent pronouncements by a bench of this court to which one of us was a member in the case of Prabir Purkayastha versus State and City of Delhi, which reads thus: the right to life and personal liberty is the most sacrosanct fundamental right guaranteed under Articles 20, 21, and 22 of the Constitution of India. Any attempt to encroach upon this fundamental right has been frowned upon by this court in a catena of decisions. In this regard, we may refer to following observations made by this court in the case of Roy V.D. versus State of Kerala. The life and liberty of an individual is so sacrosanct that it cannot be allowed to be interfered with except under the authority of law. It is a principle which has been recognized and applied in all civilized countries. In our Constitution, Article 21 guarantees protection of life and personal liberty not only to citizens of India but also to aliens. In our view, the liberty reserved by this court vide its second order to revive the request of the appellant will have to be construed as a liberty given by this court to revive his prayer afresh after filing of the final complaint charge sheet. Undisputedly, the present appeals have been filed after the final complaint charge sheet has been filed by the respondents. In that view of the matter, we are not inclined to entertain the preliminary objection and the same is rejected. Having rejected the preliminary objection, we will proceed to consider as to whether in the facts and circumstances of the present case the appellant is entitled to grant of bail or not. Insofar as the contention of the learned ASG that since the conditions as provided under section 45 of the PMLA are not satisfied, the appellant is not entitled to grant of bail is concerned, it will be apposite to refer to the first order of this court. No doubt that this court in its first order in paragraph 25 after recapitulating in paragraph 24 as to what was stated in the charge sheet filed by the CBI against the appellant, observed that in view of the aforesaid discussion, the court was not inclined to accept the prayer for grant of bail at that stage. However, certain paragraphs of the said order cannot be read in isolation from the other paragraphs. Stop.